host, Cynthia Liavule, and before we get started, please consider subscribing and recommending JurisQuestHub to someone today. Your support enables us to continue providing valuable content on jurisprudence and legal theory. Now let's get started with today's episode. Today's episode brings us to a close of the series on shapers of natural law theory, the first legal theory we have covered in our quest for understanding jurisprudence, which is basically the philosophy of law, trying to find out the nature or essence of the law, what the law is, its sources, its interpretation and application. We have journeyed through some of the greatest thinkers and proponents of natural law theory, including Plato, Aristotle, St. Thomas Aquinas, Francisco Suarez, John Finnis, and Lon Fuller. And we have seen how each one built on the others and tried to explain natural law theory. We, however, realized that the propositions were met with a lot of skepticism, notably from legal positivists in the 20th century, because of the limitations in the natural law theory. Today, there's continued high regard and appreciation for the natural law theory, as it forms a strong foundation and basis for many legal systems and discourse. Natural law theory, as we have seen, plays an indispensable role in shaping our understanding of justice and ethical limits of law. However, we're going to have a look at some of its glows and flaws, which will be useful in analyzing the subsequent theories, especially legal positivism, which arose in response to the limits and insufficiencies of natural law theory. So let's start with some of the strengths of natural law theory. It's often praised for its strong moral foundation and its insistence that law should reflect justice, fairness, and human dignity. However, it can also be termed as being practically limited, although theoretically appealing. When applied to modern legal systems, its flaws become more visible, revealing important weaknesses that challenge its reliability as a complete theory of law. And it's important to note that we are saying that its reliability is challenged as a complete theory of law, and therefore it needs supplanting from other theories of law to make up for its limits. The strengths of natural law theory can be inferred from our series, Shapers of Natural Law Theory, and some of them include, first, the emphasis on reason, morality, and universal principles, which are derived from human nature. As we have seen before, human nature is common to all human persons, and that points to the fact of reason and will, and therefore it can be argued that law is not merely a set of rules made by authority, but is grounded in the rational moral order, which is discoverable by human reason. Then it's also objective and universal, which is a strength, because it proposes that certain moral principles apply to all human beings regardless of time, culture, and legal systems. And this is good because then it forms a strong foundation for ideas of justice and human rights. And this we exemplified especially when we looked at the Eichmann case and the trial of Eichmann, because from there, although there was legal laws, we could say laws arising from authorities at the time, the trial process of Eichmann could only take place thanks to the background or the foundation of natural law, because then it could be argued that the laws at the time contravened human dignity and contravened what could commonly be inferred as universal principles of justice and fairness. Then another strength is that its rationality and practicality, its proposition as being rational and practical, as we saw by the propositions by St. Thomas Aquinas, for example, encourages the use of reason to determine moral behavior, rather than relying solely on religious context or arbitrary state power. And this makes it intellectually accessible and adaptable for ethical reasoning. And this was very evident by the propositions that we looked at. For example, Finis and later on Lon Fuller, who tried to emphasize on the intellectual aspect rather than the traditional propositions that had been given earlier on by natural law theorists. Then another important strength that I think is very important is its focus on human flourishing. Yeah. So, as developed by thinkers such as Aristotle, Aquinas, there's the linking of the law to the purpose of human life, arguing that laws should promote goods like life, knowledge, and social harmony. These are goals that all of us as human persons deep down seek. Then, another strength of natural law theory is that it provides a very strong moral foundation for critiquing unjust laws, supporting the idea that laws which contradict moral principles can be challenged as invalid or unjust. And therefore, this can provide a stable moral framework for society, and this can help to establish consistent principles for lawmaking, governance, and human rights across different legal systems. So, having looked at the two slides, we can clearly see that natural law has and continues to play an important role, especially in the application of consistent principles. Yeah. So when lawmakers are making laws, or when we're thinking about human rights, or when we're thinking about governance across different legal systems, we can always go back to natural law theory and look at these strengths. Yeah, that human flourishing, that the use of human reason, the moral standards that can be used for ethical application of laws. Yeah, so those are some of its strengths. Then let us now move on to the limitations of natural law theory. And one of the most significant limits is a lot of disagreement on the universal morality of law. So natural law, like we have seen from our previous episodes and the whole series of Shepherds of Natural Law, is built on the assumption that there are universal moral principles that can guide legal systems. But then we are alive to the fact that societies are deeply diverse and morally pluralist. I beg your pardon, pluralistic. So we have different cultures, we have different religions, we have different continents, we have different political ideologies. And of course, this means that we hold conflicting views about just what is fair. And because of this diversity, natural law struggles sometimes to answer a fundamental question, yeah? Whose morality should the law reflect, yeah? But in my opinion, I always go back to the fact that the human person is a rational being, and that gives him an opportunity to exercise his reason and his will to choose the good. So that's common to all human persons, and therefore that is a good basis for starting to reflect on whose morality the law should reflect. Yeah. So even though there's that absence of a shared moral standard, we can still go back to human nature, but then the limitation of natural law then weakens its claim to universality and makes consistent application sometimes extremely difficult. Yeah. So and some of the arguments and criticisms of natural law theory then are that if it in essence it should provide a clear answer on whether practices are morally right or wrong, and it doesn't, because interpretations of natural law differ significantly depending on cultural and ideological perspectives. So this demonstrates how natural law can lead to conflicting legal conclusions even when applied to the same issue. And an example can be seen in the historical justification of laws. For example, at different points in history, there were practices such as slavery, there was colonialism, and these were defended by some thinkers as being consistent with natural order or the natural hierarchy of people, yeah? While others argued that using natural law reasoning, that such practices were inherently unjust and violated human dignity. So from there then you have the argument that natural law does not always produce a single clear and moral outcome. Instead, it can be interpreted in ways that support completely opposing positions. Yeah. So this highlights a flaw in natural law and its reliance on universal morality, because in an unstable world where moral beliefs are deeply contested, the theory becomes sort of relative in practice, yeah? Even though there's a claim that there's an objective and absolute principle. So that is one of its limitations. And the second limitation is the in definition of concepts, yeah? So the theory relies heavily on broad and abstract concepts, yeah? So think of justice, think of reason, think of common good. So these concepts sound very, very meaningful. Intuitively, they're very meaningful, but their lack of precision creates serious difficulties when they are applied in real and concrete legal situations, yeah? Because without a concrete method for determining what counts as just or what truly serves as common good, natural law then becomes open to multiple interpretations, leading to uncertainty and consistency. So, for example, the idea of justice, yeah? So, one legal system may interpret justice as equality, yeah, that is ensuring that everyone is treated the same under the law. Then another may interpret it as equity, which is allowing an equal treatment to achieve fair outcomes. Yeah. So for example, things like affirmative action. Yeah. So all these interpretations can claim to align to natural law, yet they lead to different legal outcomes. Yeah. So although it shows that natural law does not provide a clear standard. Yeah. The result is options, yeah? So similarly, the concept of the common good, yeah? So sometimes it can be quite ambiguous, yeah? Although using human reason and the will, we sort of can objectively define what common good is, yeah? But it could be ambiguous. So for example, during the COVID pandemic period, yeah? Governments imposed lockdowns and restrictions on movement because of the common good. So there were arguments that some of these measures were justified because they protected public health and saved lives. But there are others who claimed that they violated individual freedoms and therefore were unjust, yeah? And you can see both could appeal to natural law theory, yeah? One emphasizing that collective welfare, and then the other emphasizing individual rights, demonstrating how the same concept can justify opposing positions, yeah? Then thirdly, another limitation is the risk of subjectivity in interpretation, yeah? So the risk of subjectivity arises from its strong reliance on moral reasoning, yeah, because natural law the claim has the claim that, yeah, it's grounded in morality, yeah, that law and morality cannot be separated. So of course judges, scholars, lawmakers interpret what is morally right or natural, yeah. But just like human beings are diverse, then moral reasoning is not uniform. It's often, more than we like to admit, shaped by personal experiences, cultural background, religious beliefs, political ideology. And as a result, individuals applying natural law may unintentionally maybe project their own values into legal interpretation while presenting them as universal truths, yeah. So for example, in cases involving criminal punishment, yeah, one judge might believe that justice requires harsh retribution because it reflects moral accountability and deterrence. Then another judge may apply the same idea of natural law, then argue that justice is better served through rehabilitation and mercy, emphasizing human dignity and reform. So both are appealing to natural justice, but they reach completely different conclusions based on their personal moral outlook, yeah? So we can see that the legal outcomes are different, and therefore like a legal positivist would argue that there should be clarity on what the outcome should be, and natural law doesn't seem to give that. Then a similar debate as regards the risk of subjectivity can be seen, for example, in debates of human rights and morality-based legislation. So for instance, one legal scholar might argue that restricting maybe certain behaviors, let's say gambling or consumption of alcohol, is justified under natural law because it protects moral order and the common good. And then another might argue that the same restrictions violate natural liberty or individual autonomy, which they also consider part of natural law. So the same theoretical framework can be used to support opposite policy positions, and this is because of that risk of subjective interpretation, yeah. And this has been historically maybe proven or shown to to support ideas presented as natural order, yeah. So yeah, like we mentioned, colonial rule, or during times of gender inequalities or social hierarchies, yeah, with the claim that these arrangements reflected nature or reason, yeah. And later on, of course, we have criticisms that such orders, of course, were fundamentally and unjust, yeah. So natural law reasoning, it's a good thing actually, yeah, then, because then natural law reasoning allows for the law to be malleable, allowing it to support reforms, but then also at some points, like we have seen historically, it's been used for oppressive arguments. Then another limitation is the tension between natural law and legal authority. Yeah, like we mentioned during the classical proponents of natural law theory, St. Thomas Aquinas, later on Suarez, there was always that sort of tension, yeah. In comparison to legal positivism, natural law is at times considered to cause tension with legal authority, yeah, because it encourages individuals to question and even disobey laws they consider unjust, yeah. So this can serve as an important moral safeguard, but also it can weaken legal certainty and stability, yeah. So if the validity of law depends on individual moral judgment, then the binding force of law becomes uncertain and can create confusion. And in that sense, natural law critiques authority effectively because it doesn't explain how legal systems should function in practice, yeah. And then this I like because then we have to look for pragmatic alternatives, yeah. So the theory of natural law sometimes has limited offers for alternatives, yeah, otherwise referred to as problem-solving capacity, yeah. While it's powerful in identifying and criticizing unjust laws, sometimes it doesn't always provide clear or practical alternatives. It tells us what is wrong, but not necessarily what should replace it, yeah. So, and this highlights a deeper limitation, yeah. Natural law is strong as a normative theory because it's focused on values, on ideals, but then it becomes weaker as an operational tool that can guide specific legal actions and decisions, yeah. So like we've mentioned before, like in the criminal justice system, yeah, we can be very clear on what is a harsh punishment or what is unjust. But then, for example, we need specifics relating maybe to the types of punishment, sentencing rules. Yeah, we need clarity on that. Yeah, and that is why then the results will be different. Systems will choose different things, maybe rehabilitation, deterrence, retribution, and those criticizing natural law then will argue then that natural law leads to inconsistency. Then in terms of civil rights laws, yeah, so for example, when you talk about equality, yeah, so we need clarity on how equality should be implemented, yeah, is it formally or substantively, yeah. So, and that is why then you'll have different outcomes such as strict equality and affirmative action policies. So the flaws that we've talked about, at least for me, point to the risk of human freedom, because I think natural law theory gives a lot of space for the exercise of human reason and exercise of the will, but rooted in a deep understanding of human nature and and the good of the human person, and also the common good. Yeah, so these flaws demonstrate not only the flaws of natural law theory, but also the broader limits of jurisprudence itself. Yeah, so if nothing else we get from the episode, I think that is what it does. Yeah, that the broader limits of all jurisprudence and also all the legal theories that we're going to look at. Yeah, but natural law theory remains important because it connects law to morality and challenges unjust systems. And then also it forms a very strong foundation for the safeguard of human dignity, the human person. Yeah. However, the weaknesses of like the ones we have mentioned show that it cannot function effectively on its own. Yeah. So law cannot rely purely on moral theory. It also requires structure, clarity, enforceability, which are better addressed by other theories. Yeah. And one of them that we look at is legal positivism. Yeah. So in conclusion, we could say that natural law helps us understand what law ought to be, but its flaws reveal that it cannot fully determine what law is or how it should function in complex modern society. That is why we need a balance between moral ideals and legal structure. And natural law provides a challenge for legal reasoning that ultimately allows for the exercise of human freedom at the risk, I could say, at the risk of making mistakes, but aiming for what is inherently and objectively good for the human person and what is good for all human persons, yeah, the common good, yeah. And of course, most importantly, his dignity as a rational creature with the capacity to choose what is morally good. So this brings us to the close of today's episode on the promise and pitfalls of the natural law theory. I put the globe and the compass there to sort of depict the promise that natural law theory gives of the universality and the human flourishing that it promises as well. But then the pitfall, as we started in, I think, our second slide, then depicts also the flaws, the flaws of natural law theory. So I hope that you were able to learn something from today's episode. Please feel free to share your thoughts on this episode and any of the episodes of Shapers of Natural Law Theory. And don't forget to like, to subscribe, and hit the notification button for our next episode. And just to give a heads up, JurisQuestHub will be taking a break, but feel free to catch up on any episodes you missed and spread the beauty of legal philosophy and legal theory. See you soon.